What are some common weaknesses that you see in early stage biotech companies from a legal or IP perspective?
There's a lot to talk about here, but
Mhm.
let's hit sort of the top three. I think one of the most common weaknesses we see are situations where an inventor is filing their initial patent application too late. So you have a situation where an inventor or a company founder gets really excited about the science. They go out, they present it at a conference, or they publish it, and then they come to me after that initial public disclosure has been done, and that's a problem. So in most of the world outside of the US, a public disclosure before the first filing date prevents you from obtaining a patent. And even in the US, you have a 1 year grace period, but that is not something that you want to rely on. So one of the most important things I think that I would like to get to all inventors and founders out there is, if you've got a great idea, make sure you can develop it and get your application filed. That being said, filing too early is also a problem, especially in biotech or life sciences. And I think that's a situation that is often underappreciated by inventors and founders. So if you file an application before you really have sufficient data to support broad claims, you may be able to get a patent to issue eventually, but it may not actually cover your final commercial embodiment. And there's a number of reasons for this. Science inherently evolves as you go through your R&D process. So for example, your particular small molecule might get optimized, your formulation might change, your indication might shift depending on what your preclinical trial work looks like. And the patent that you filed in your first year may no longer map to the product that you actually end up developing or planning to commercialize in year 5 or later. So in this regard, you end up consuming a lot of patent term, and you've created a public disclosure that competitors can read, but you don't end up really protecting what matters. So timing the filing to capture the right inventive concept with the right data behind it, it's really one of the most important and consequential strategic decisions that an early stage biotech company could make. And the third one that I see over and over and over again has to do with IP that's not fully owned by the correct entity. So for example, ownership may be spread between a university, a prior employee, or a co-founder who's since left the company, instead of being consolidated with the commercializing company. It's not an unsolvable problem, but it really is important to get the chain of title on your intellectual property right in the beginning, because this is something that can be very hard or challenging to clean up later or after the fact.